Let's go. Yeah, make it look easy. Hey, stand up guy on 10 toes. Big body pull up in a Range Rover. I can change the whole game when I say so. I pull up, shut it down, yeah, they know. Running this game ain't a thing for me.
We're on the record, case number 2003 VR 6755, Department of Revenue on behalf of Cleve Ball versus Sir Doss. Mr. Doss is appearing via Zoom, as is Ms. Comrie, who represents the Department of Revenue, and a Department of Revenue representative. We're here on the respondent's driver's license contest or motion to contest suspension of driver's license and request for hearing. Mr. Doss, before we proceed, I need to let you know that I used to work at the Office of the Attorney General and I represented the Department of Revenue. The department is a party to your case. If for any reason you feel you cannot get a fair hearing from me, I'll remove myself from the case and one of the other hearing officers will hear it at a later date. I looked at this file and I didn't work on this file when I was an attorney for the Department of Revenue. However, I do have some recollection at some point of working on one of your cases. It must have been another case. Do you have any questions about what I just told you?
No, I don't, but to your statement as to whether I could get a fair hearing, I think that my volume of filing would show that I don't think I'll get a fair hearing, but we'll go ahead and shoot for it. You don't need to recuse yourself. I see you say Mrs. Comrie. I can't see the face, but I'm looking at C-O-M-R-I-E. Is that the attorney for the Attorney General's office?
Yes, she's with the Attorney General's office.
Okay, so I was expecting Mr. Arena, so if possible, without me having to be more formal, I'll request her information as well as our information. I'd like to look it up, but I don't know if that's the proper spelling. Ms. Britt is here, I guess, to give testimony as to the factual basis of whatever the department's arguments may or may not be.
Yeah, she's the representative for the Department of Revenue. Unfortunately, Mr. Arena is deceased. So.
Oh, sorry to hear that.
Yeah.
Okay.
So, so Mr. Doss, do you want me to proceed with the hearing, or would you like somebody else to hear it?
No, you can hear it. You know, the facts are the facts.
Okay, so you're waiving any potential conflict?
I'll stipulate that you can hear the case without having to recuse. Now, whether there's a conflict, that probably would be a meritorious determination. But
well, you either waive it, because I don't want you in the future to say I had a conflict and my order is invalid because of a conflict. So you can waive it, or somebody else can hear it.
Factual, Mrs. Campbell. I'm pretty sure we will be able to resolve the matter now. So
all right. So it's your motion. You can proceed.
Okay. So there's a couple of issues that are foundational to this case that would require the case to be reversed. You said that you received my filing for this case, correct? My motion to contest, as well as the attached exhibits. And I guess I should be asking that question to Mrs. Britt and Mrs. Is it Comrie?
Yes, it's Comrie. C-O-M-R-I-E. First name Hulda.
Hulda. Okay, Ms. Comrie, did you receive my motion to contest the suspension of the driver's license?
I did.
And did you review it?
I did.
Okay, that's fine. And Ms. Britt has also received the motion to contest?
I don't know.
I'm asking her.
Ms. Britt, have you received the motion to contest? Ms. Britt?
Shorts in here, wearing platform.
Okay, so is it possible for Ms. Britt to testify to information that she doesn't have a first-hand accounting on?
Absolutely not.
Okay, so that may raise an issue, so I'll object to her presence beyond her being here as a body for the Department of Revenue.
She's here as a department representative. Let's see where we get with what we have.
Okay, so let's get to the basis of of my motions. One, the children are emancipated. The mother also filed a affidavit back in 2013, I believe, stating she wanted no more participation in the case. Is it the Department of Revenue's position that the Department of Revenue is owed anything? Whether it's Ms. Britt or Mrs. Conner.
Well, Ms. Comrie would have to answer whether there's any public assistance owed. I saw your statement or your averment, and I saw that the department closed their case after that. At some point, the case was reopened, and so I saw what you filed as the exhibit. I saw Ms. Ball's statement, and then the department shortly after that filed a notice closing the department's case. But as this is a judicial case, it doesn't close the judicial case without a court order. So was there a court order after that, Mr. Doss?
The court order that would be contested would be the original order. And I see that Mrs. Britt is saying that $835 is owed to the state. Is it the state's position is owed by me?
I guess it's on the case. Ms. Britt, do you have laryngitis or something that you can't talk today? Okay, because it's not proper to be putting the testimony in the chat, because there's a court reporter present, and the recording also doesn't pick it up. So I'm not sure how we're going to proceed, but Ms. Britt did put in the chat that there is $835.49 owed to the state.
I'll stipulate to agree that that's what I see as well, and I'm pretty sure that the attorney sees that. I would prefer Ms. Britt to make her statement on the record.
Well, she hasn't spoken all day, so I believe her when she says that she has laryngitis.
Oh, yes, that she has laryngitis.
Yeah, because she's been here since my 8:30 hearing and hasn't spoken. The first thing she says, so I do think she probably has laryngitis when I heard her speak. All right.
I have no objection to admitting her statements in the chat room.
Okay, Mr. Doss, let me ask you this. In all the times that this case has come forward after that, has Ms. Ball ever appeared for any of these hearings?
She's appeared, I don't know when the date was, but she appeared one time after filing the affidavit. And what's kind of interesting without Mrs. Ball, the affidavit essentially on its face stands for what it is. Mrs. Ball has already stated she wants nothing to do with it. She wants no entitlement to arrears. And before I infringe Mrs. Comrie negatively, I would think that I would allow her to offer to just close the case and disregard the $835.49 so that we don't turn this into something that it doesn't have to be.
Well, good luck with that. I've never seen the state give up any of their arrears. But so I'm looking, so she signed this in November of 2013. So the general procedure in a case like this, because it's not unusual to see people saying they want to close their case, is that they need to come to court and ask that a court order be entered to stop the child support. So we need to have Ms. Ball here rather than going on an affidavit. Do you have any contact with her?
No. But I would state that the affidavit in and of itself, although rebuttable with the testimony, and unless somebody's going to contradict the truthfulness of the affidavit, I would move the court, you to enter it into evidence, because it is in the clerk's record, and the clerk is the one who signed the affidavit. And if you can get that without objection, then I think we just put it into evidence, and we can move on to really the foundational issue for the reason that the motion to contest driver's license should be granted and the case reversed as an operation of law.
All right. Ms. Comrie, any objection to Mr. Doss's Exhibit D being admitted into evidence?
I have no objection. it's in the clerk's docket as well, Ms. Comrie.
It's Exhibit D to the,
The affidavit, no objection.
all right. All right, I'll mark the affidavit of fact signed by Ms. Ball and dated November 20th, 2013. And
Okay. And as to the $835.49, I'll just state in going to Feliciano over Department of Revenue 305 SO3E 801 and 803. The improper calculation of a child support obligation amount pursuant to the child support guidelines, fundamental error that may be raised at any time, and I'll do it now. And because the original proceeding did not include myself or Ms. Ball, there is no competent substantial evidence upon which anyone, not only the hearing officer, who is, I have no issue with Ms. Jello, nor a judge, could have made a determination as to any amount. Furthermore, there's no affidavit in the record attached to that final judgment as well, and we can just go to Florida Family Law Rule of Procedure 12.285, subsection J, which demands the necessity of a child support guidelines worksheet, and I'll read it, and I believe everybody should have it because I submitted it with my filing as an exhibit. If the case involves child support, the party shall file with the court at or prior to a hearing to establish or modify child support, a child support guidelines worksheet in substantial conformity with Florida Family Law Rules of Procedure 12.902E. This requirement cannot be waived.
did you see the item that was filed on August 10th, 2004?
The final judgment, I believe, is attached to my filing.
Yeah, but the guideline is right there.
Who testified to the guideline?
I'm just saying, you said there is no guideline. I'm looking at the guideline.
In conformity with do you see the form 12.902E? And now we could all look it up.
Okay, so what statute are you reading from, sir?
The case, I cited.
No, the statute you said, because that, I don't
No,
know.
I cited the rule, Ms. Campbell.
Okay, which one was it?
12.285, section J.
Okay.
But we have a few more things.
Well, I just want to know, was that in effect in 2004?
Yes. It had a different statute name, but it was in effect then. But what would be in effect is there's no competent substantial evidence because clearly from the findings of fact and recommendation, neither Ms. Ball nor myself was there. So there would have been nobody to bring any evidence to include the financial affidavit to make the determination. There's no competent substantial evidence for not only the hearing officer to rely on, but the court, because I'm sure we all know that an attorney can't admit evidence. And it would also survive the exception rule as well.
Okay. There is a verified financial affidavit filed in May of 2003 with the petition. But Ms. Comrie, I'll let you address Mr. Doss's statements regarding the order being void or avoidable.
Or reversible. And before you go, Ms. Comrie, I think I can make this a little more expedient. An order granting child support must be reversed where a child support guidelines worksheet is not attached to the final judgment. And you can go right there to the Department of Revenue, Extra Relations, at CAN versus ANG, and that's 165 SO3E 846, 848, and that came out of the Second District Court of Appeals. And it also refers back to Florida Family Law Rules Procedure 12.285, and K is in kilo.
Now, what year was that decision?
2015, and unless you want to proffer any information that states that it didn't apply then, I'll just ask the court to rely on it because it would still be reversed if it came out then.
Okay, Ms. Comrie?
even if it wasn't exactly attached to it, the financial guidelines that Mr. Doss filled out was filed along with the guidelines on how the calculations were established, and so those followed the final judgment. So I don't see how it's reversible error when they both were filed and then they were mailed to your last known address. So you had notice of them. So if there was a problem, you should have brought it back then if you thought it was reversible error, because it was filed the way it was supposed to have been filed in accordance with the rule.
Objection.
You're saying it wasn't filed. It was filed.
Oh, I'll object to what you're trying to offer now. Unless you have contradicting case law or statutory or some statute or rule that states that it's not reversible. I'm certain, Ms. Campbell, you see it as well, correct?
No, I'm just aware that recently there have been court orders saying that it's reversible, but you haven't, this order has been in effect for probably 20 years now.
There's nothing in the record, nothing in any case law or anything that's been presented by anybody that says that it's not reversible because it doesn't make people feel better.
Okay.
Furthermore,
I didn't say about making people. You filed under 12.540.
and I'll stand on it.
Okay, which states that it either had to be a clerical error or mistake, fraud, neglect. So, which one is it?
It doesn't have to be either one. It's reversible because the attachment is not there to the final order. And I believe that's actually an exhibit, isn't it? Are you disregarding the exhibits? Just for the record.
No, I see the final order and I see the child support guideline worksheet that was marked by the hearing officer the day of the hearing.
Okay, and as you see that neither Ms. Ball nor myself was there.
Okay, that is not necessary. If she was receiving any public assistance, the department is subrogated and can appear and request the child support without you or Ms. Ball there. Why weren't you there?
I don't know, and I don't think it's relevant.
Well, I think it is relevant because otherwise we could have all these obligors not showing up and saying, you can't proceed, I wasn't there.
No, I don't think I argued that you couldn't proceed because I wasn't there.
Well,
I might argue that you did not have any competent, substantial evidence to rely on to create the original order. And when I say you, I'm imputing whatever the other hearing officer said or did to you. There is nobody there to verify anything. And unless Ms. Comrie, in contravention of the Florida Rule of Professional Conduct, when we go to 4-83 or any other ones, we're going to say that an attorney could have verified it. There's nothing that the court could have relied on. There's no competent, substantial evidence in an order that's not based upon competent, substantial evidence is reversible as well. It's a due process issue. I think we're splitting hairs when we don't have to. If the issue is at $835.49, I need somebody to come in and swear that $835.49 is owed, and that is owed based upon some, I guess, petition or some cause of action raised by Ms. Ball, I believe, because the state's not the one doing it. I don't think.
Well, the state is enforcing it at this point. So let's get to your driver's license.
There's no time sharing agreement either. So what are they enforcing?
They're enforcing an obligation to pay child support.
I don't want you to answer it. I want somebody.
Well, I want one answer. What's going on with your driver's license? Let's get to that.
That's probably more for you all. Nothing should be going on with the driver's license. It's not suspended for that.
Okay.
But I will say too, we stay in conformity with well-established law. I need somebody to come in so I can cross-examine them as to who's claiming I owe $835.49 to the state. And then if they want to state that that's what the controversy is, then we'll stipulate to argue the $835.49. And then, we can go to 61.1354, and I'll challenge that, and we'll be spinning around in circles about it. Candidly, I believe this is more of an abusive process.
All right. So, sir, back to that. What's the status of your driver's license?
As it relates to this case, there's no status. It surprised me this came out of nowhere.
So, has it been suspended, or is there a suspension?
Not for this case. No.
Okay. But you filed a driver's license contest.
Because I was sent an intent to suspend my license. So I responded within the 20 days as required by rule.
Okay. So, Ms. Comrie, is there still a driver's license suspension activity, or is it moot?
The driver's license is on hold.
Okay. All right. So,
He also has like another case next week or so in front of, I think, Denton. So I don't know if that could also be, I think he filed a driver's license for that case as well.
okay, you've got another driver's license contest, Mr. Doss?
Well, I think that's a little bit outside the scope for this case, but there's an issue in a case involving a challenge to jurisdiction, which the court nor the department has answered, where the department filed, and I haven't even seen a petition for the case, back in 1995, a petition for a party that, well, I put it this way, there's no petition that pled proper jurisdictional grounds to give the state of Florida the authority to bring an action on behalf of a non-resident of Florida. And that was filed outside 120 days, and then there was a default judgment based upon improper service. So that.
Now, all I needed to know if you had another driver's license motion pending.
Yeah.
All right. What I'm going to do for today, because this was only set for 15 minutes and we're already over, I'm going to continue your motion to be reset for, how much time do you think you need, Mr. Doss? 60 minutes, 30 minutes?
For what? I don't need anything. I just need you to move to recommend that the court, that the judge do his job or responsibility and make a ruling based upon well-established law.
No, you said you wanted testimony about the 835-49. You're arguing that Ms. Ball...
Ms. Britt can do that. She's the representative of the state. Ms. Smallwood doesn't have a claim against me. There's no independent action involving me and Ms. Smallwood. Ms. Ball has never filed an independent action.
Well, that needs to be determined, because that might resolve the whole case if all is owed to...
Mrs. Britt is a representative of the Department of Revenue. Am I correct?
You're correct.
Okay, so Ms. Britt can answer the question as to whether the state is making a claim that Shagrat Doss owes the state $835.49, and if so, for what?
Okay, Ms. Britt, are you able to testify regarding that today? Can you talk at all? Or?
Yeah. I can stipulate, she can type it in. I'll stipulate that you can type in your answer.
Yes. All right.
Yeah.
Can you please raise your right hand?
I don't see it yet.
Oh, I saw a yes there under that other. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Okay.
All right. So, Mr. Doss, go ahead.
Ms. Britt, is it the state of Florida's position that I owe $835.49?
Yes, to the state.
Can you articulate for what I owe the state $835.49?
Money paid out for the child while the child was under the age of 18.
For what child specifically did the state pay $835.49?
I don't know what your name. Stay alone. Oh.
Okay, can the state provide what specifically it did for Jaylon Ball that I would owe?
State provided Medicaid, food stamps, and cash assistance.
Does the state have evidence to support their allegation that they gave $835.49?
Yes, that's how we have that number cut into the trackable account.
Okay, I said, could you provide evidence?
Me? I cannot now at this exact moment, but we
And
can.
I'll
Right.
I'll object and just call it hearsay, and we can move forward until the state can prove the $835.49. And by the way, that $835.49 come before or after the affidavit in 2013?
What's happening is
The affidavit submitted by P. Ball in 2013, and it's attached to exhibit B. Yeah.
exact dates.
I couldn't hear you, Miss Britt. Okay, so
Yes,
she,
that date.
I don't have the dates.
Okay. Also, I want to turn the hearing officer's attention to the termination of services. She didn't have the date at all, so I guess it's a moot question. Go ahead and strike that, what I was going to say. So this is what we'll do. I think the state is the one that needs the time, not me. The state hasn't proven that, one, that the case law that I cited is not applicable. Two, and the state hasn't shown why, if, and how I can owe $835.49. And unless there's something that was, oh my goodness, what happened? What happened? Hello?
Nothing happened. What's?
Oh, okay, you just disappeared. Okay.
No, I'm like, what's going on?
Okay. If there's nothing that anyone wants to give testimony that would overcome the case law that I presented, then I would just ask that you, Ms. Campbell, make the proper recommendation to the judge and tell the judge that based upon well-established case law and there's no exception, no rules exception that would qualify anything to the contrary, to go ahead and just close out the case that they had before. And by the way, you know that on May 19th for Mrs. Comrie, on May 19th the department terminated the services as well, so that date will be pretty important to know.
May 19th of this year?
2015.
Okay, but what they do, I mean, we've all seen all these cases, they terminate services and then they jump back in.
Well, that would also require a recalculation. I don't think we need to get into the weeds and split hairs about that.
Okay.
I think we all kind of know where this should go.
Okay, so Mr. Doss, let me just say this one more time. The Department of Revenue brings these cases on behalf of the custodial party when there are minor children involved. When it's a court order, whether the parties sign an affidavit or the department jumps in or out, the court order stays in effect until there's another court order either suspending or terminating support, so that those charges continue charging even if the department is out of it for 10 years. So you can't just suspend a court order based on a letter from the Department of Revenue or an affidavit. So I think that's part of the misunderstanding here.
Well, I don't think there's a misunderstanding. I'm not arguing that, Ms. Campbell. I'm arguing that because the prerequisites to establishing an order were not met in 2004, meaning that there was no attachment of a child support guidelines, no attachment of financial affidavits by both parties, and there was no stipulation by the two parties, myself and Ms. Ball, or actually not even Ms. Ball, myself and the state, that we were not going to submit financial affidavits, which, by the way, those disclosures are mandatory, we all know, without me even getting to that thicket. And there's no time sharing agreement. So we have no competent substantial evidence, no time sharing agreement, no mandatory disclosures pursuant to 12.285, and there's no guideline worksheet attached. I'll rely on the rule and I'll expect you to perform your duty and ask the judge to rule accordingly. Beyond that, the only issue is the $835.49. With that being said, I think we're pretty much finished. There's no, and by the way, there's no witness here to anything else, and Mrs. Britt has already admitted she doesn't even have any evidence to support the $835.49, so I couldn't even make a proper objection under 61.1354.
All right, Ms. Comrie, your response?
The department would end up proceeding with the fact that he owes the $835 and change towards that child. The department would still be seeking that amount of money. And the fact that Ms. Britt doesn't have the dates doesn't mean that there isn't evidence that the department can submit if we continue the hearing and submit it for his review, that the money is owed, how it came about, and why they're still going to proceed, even if Ms. Ball doesn't, want to proceed with her portion, because the department would still proceed with theirs and the money that's owed to them.
Just for clarity, and I want to make sure that the record is clear, is it Mrs. Comrie's position that she is offering information as evidence as a witness, or just in contravention of your responsibility as an officer of the court? Because if you don't have any evidence, you shouldn't be speaking to it.
Ms. Comrie, what's your position?
I don't hear her.
My position is that we don't have the information for today's hearing, but the department can get that.
I heard that the
That's
first
not
time.
the part.
I heard that the first time, Ms. Comrie. I asked you a specific question. Is it your position that you are offering testimony to evidence that you cannot support as an officer of the court? Or are you saying, Ms. Campbell, are you telling Ms. Campbell you want to move forward?
Records.
Ms. Britt didn't make the comment. You made the comment. Is it your position?
No, Mr. Doss, don't
Ms. Campbell.
badger the attorney. You're also acting as an attorney. I haven't sworn you in.
I'm not now.
Yeah, you are, because I haven't sworn you in. I've let you make arguments. But so the clerk shows.
You want to swear me in? Can we start all over again?
No, it's fine, because it's an argument issue.
It's not an argument issue.
It is. You've been arguing.
That's a fact, Ms. Campbell. Listen, you're an attorney too. We're not going to play this game. If you want to continue, I say I grant you to continue. Do not ever have an attorney do what she just did again.
She is stating, based on what Ms. Comrie stated, as to what the...
No, Ms. Comrie made the statement.
Yeah, correct. She's the attorney. Ms. Britt is her client.
She can't testify, Ms. Campbell, and you know that.
That was an argument, sir. If she says the clerk, okay, I'm not going to argue with you, Mr.
I didn't think
Doss.
so. Now, see, you made this thing turn in a different direction. I'm trying to be kind. I said, if you want the continuance, I'll grant it. But what
It's not up to you to grant a continuance.
I'm not an attorney violating her oath to the doggone law. I just heard what she said.
Okay, Mr. Doss, it's not up to you to grant a continuance. All right?
No, I said I would not object to her continuing. I would object to her trying to present information as evidence that she can't support.
All right. So, Mr. Doss, is there anything you can pay to keep your driver's license?
I'm not paying anything for an order that you can't substantiate.
Okay. All right. I'm denying your motion.
Okay.
There's a child support guideline in the court file.
Is the child support guidelines attached to the final judgment?
It might have been, the clerk might have separated it, I don't know, but there's a child support guideline stamped.
Hold on, wait, we're not doing that.
Sir, I'm making my ruling, I'm not going to argue with you during my...
Wait a minute, it's attached as an exhibit.
It's here on August 10th, 2004, it's stamped by the hearing officer, August 9th, 04.
Is it attached to the final judgment?
Well, Mr. Doss, I don't know if it was attached. It was as an exhibit, and it's part of the final judgment, including the income deduction order, the notice of filing, and everything else that was done on that day. There's also a financial affidavit of the mother that she filed in the case. So okay, sir.
To the final judgment is my
Okay.
question to you.
Okay, I'm denying your motion, Mr. Doss.
Let the record reflect that Ms. Campbell cannot, or did not, and did not force anybody else to answer whether or not the final judgment includes the financial affidavit, the child support guideline, and any testimony from any competent person and witness.
Okay, Mr. Doss, I'm not here to answer your questions, all right? So I'm just saying, your motion is denied. There's guidelines in a financial affidavit in the court file. I do not find a legal basis to set aside the final judgment of support. Your driver's license is still valid. You're refusing to make any kind of offer for payment to keep your driver's license. So I'm denying your driver's license contest, and the department may proceed with suspension.
I'll object to that because there's no...
All right, so you'll get a copy of this order. You're aware of the vacate rules. You can file a motion to vacate if you wish, and have it heard by a judge. All right, that concludes the hearing. Have a good day, sir. Thank you.
Take care. Bye.
Yeah, make it look easy. Hey, stand up guy, boom, 10 toes. Big body pull up in a Range Rover. I can change the whole game when I say so. I pull up, shut it down, yeah, they know. Running this game ain't a thing for me. I never switched up, no change in me. The only thing changing this season, you go against me, then you know that you tweaking, okay? Cause baby, I'm him, I be on 10. Two-stepping in the party, I do not dance. Watch how I move, make it look easy. Counting up wins, that's part of the plan. Blackmail, taking up my haters a CC. That can't fail, all my victories will repeat. I'm knee deep, need a dub, best that you seek me. I'm too sick, yeah, I know I make it look easy. Easy, yeah. Tell them don't try to play me. Yeah, I'm drippy on the daily. They can never count me out. They can never count me out. I know. They can never count me out. They can never count me out. I know. I make it look easy. Make it look easy.